With that, members, House File 1103 is the first bill up. It's by Representative Thompson. The chair moves to refer House File 1103 to the Judiciary Committee. Representative Thompson, welcome to the committee. I think this is the first time, you've been here as an author of the bill. You have been here in the past as a pre-Representative Thompson age as an advocate on a number of issues. I recall some investment issues for youth intervention work last year or two that enjoyed some really good support. So I look forward to hearing about your bill and having a good conversation as well. There is an author's amendment that will shape the bill the way in which you have asked it to be heard today. And so if you wish, I can move that at this point. Representative Thompson.
I'm sorry, I was on mute, Chair. Yes, I would like for you to move.
You know, you're the only one who's ever been on mute, you know. It happens on a daily basis. Very well. The chair moves to amend House File 1103 with the A1 amendment and author's amendment that shapes the bill up for our discussion today. Representative Johnson, you okay with a voice vote, or do you want to roll on this?
We can just voice vote this one.
Very well. Thank you, sir. All in favor of the A1 amendment, adopting the A1 amendment, please say aye.
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 Opposed, same sign.
No.
Motion prevails, and the A1 amendment is adopted onto House File 1103. Representative Thompson, your bill as amended in the form you wish it to be today. Tell us about your bill, and then you've got several testifiers, and then there are also additional public testifiers to your bill. Representative Thompson, welcome to the committee.
This is Bill 1103.
1103, yes.
This is a bill for an act relating to public safety imposing duties on police officers and law enforcement agencies regarding video and audio recordings, use of deadly force, providing for civil remedy, proposing coding for new law in Minnesota Statutes, Chapter 13. Chair, I want to share something real quick. July 5th of 2016, I stood outside of the store and I spoke to a great friend of mine. And we talked about the murder of Alton Sterling, who was murdered in Baton Rouge. And we shared the same sentiment that the video evidence would come out and nothing would happen as far as any type of accountability. And we were so numb to that police-involved shooting on that day, July 5th, 2016. The very next day, July 6th of 2016, my good friend was murdered within the same way we discussed outside of that store. Body camera footage came out and it showed that there was negligence. There was a jumpy officer on the gun that ultimately killed my good friend, Philando Castile. And I came before this body asking for a lot of significant changes within policing, and we got implicit bias training and de-escalation training. We also got money for that training, and I feel like it was off the blood of Philando that we got this money for this training. And here we are, 2021, and we're looking at a training sergeant kill a young man by the name of George Floyd. Every year we're here, and we're here because of one reason, and that's bad policing. Not saying that all police officers are bad, but the bad ones are making the good ones look very bad. And so I'm here before this body today asking for exactly what the community that I serve need, and that's some changes within policing. And I have a lot of testifiers, and so for the sake of time, I want to leave it. I'm by no means a professional. I'm just a professional Black man. And so I just want to leave it to the testifiers. And if you will, Chair, because I don't want to take up all the time. It's not about me. I promised this body in 2016 that I would be the change I want to see. And here I am, because I was just like some of these testifiers just last year, except for I really want to see change. I have never been more passionate about anything I've done in my life. Here I am before you, being the change I want to see in my community. I am a Minnesota legislator now. And so I want to say thank you, Chair, for the opportunity of hearing this bill and pass it over to Jonathan McCullum.
Very well. Thank you, Representative Thompson. Mr. McClellan, welcome to the committee. I obviously state your name for the record and give us your testimony, but let me ask you this, sir. If you could perhaps walk us very quickly through this bill. If not, I can certainly have our counsel do that. But I prefer to hear from the public as much as possible. Mr. McClellan.
Yes, Chair and members, my name is Jonathan McClellan. I am a retired Minneapolis firefighter, retired due to an injury in the line of duty saving a young man's life. I am president of the Minnesota Justice Coalition and law student at the University of St. Thomas. I would like to thank this committee for giving me an opportunity to share with you today. And I would like to thank Representative Thompson for carrying this important piece of legislation. The common thread that you hear throughout all the families' cases who lost loved ones to police violence is that the information is kept by law enforcement and the information sought often stalls out potential cases. And the family is left to suffer not knowing what truly happened to their loved one. You should not have to wait 10 months or 11 years to know what happened when your loved one is killed. One case in particular which inspired this legislation is the case of Kobe Heisler. Kobe Heisler was a young autistic boy who was killed in his grandparents' home by law enforcement on August 31st, 2019, following a mental health incident. While meeting with many other families who lost loved ones at the hands of law enforcement, Kobe's mother, Amity, was notified that she would be allowed to see the footage of her son's death. This happened to be 1 week after the death of George Floyd. In early June 2020, almost 10 months after the death of Kobe, Amity was told that the only people that could see the law enforcement videos was her family, and then that changed the day of the schedule of the viewing. To add to her pain and grief of losing her son, Amity was overcome with grief to the point where she was unable to stand. She was not allowed a chance to properly grieve for her son because she was kept in the dark on what really happened. There are many similar cases when it comes to families requesting information. These families are put into a yo-yo trying to figure out what happened to their loved one. And oftentimes this goes on for years. In another case, we are still receiving contradictory information after 11 years of being told that it didn't exist. We were able to find a video. In a recent case out of Minneapolis, the police released one video to justify the killing of a man named Dalad Eid, allowing that narrative to simmer in the community while holding on to all the cards, rebuffing the family's pleas for transparency and access to all the videos while the family is still grieving. And as a state, we can do better. On Saturday, March 20th, Hennepin County Attorney Mike Freeman told a working group of 16, including Attorney General Keith Ellison and Minnesota Commissioner of Public Safety John Harrington, regarding any police-involved deadly force encounters, that any video related to the death of a citizen should be made public as soon as possible, but in all cases within 45 days of the incident. Taking this into consideration, we agreed to giving law enforcement 90 days to fully release the videos and audio to the family and or their legal representative. When law enforcement agencies withhold video evidence of police misbehavior, the other details concerning the deceased are usually released shortly after the incident. The decedent's prior criminal record, whether or not the person possessed drugs, the blood test results, and coroner's report are made available to the media. The priority of the families gets lost in this process, and that needs to change. Oftentimes, the video and or audio is released by law enforcement. It will be selective in spinning a narrative in the media that benefits one side. Oftentimes, these media dumps are misleading and cast a negative shadow on the person who was killed, forcing the families to fight an uphill battle to clear their loved one's name while trying to grieve. As part of his earlier statement, Mike Freeman said, "We share these remarks with a profound commitment to deal fairly, transparently, and as professionally as we can in each case. We assign our most experienced people to allocate all of the resources necessary to reach justice," end quote. These families need to be allowed to access this information to manage their trauma and pursue justice wherever it may come. This club's membership is unsolicited and paid for in tears and sometimes in blood. It is important to ensure that transparency and trust is the bedrock and or foundation of our government's institutions, and any opportunity we have to improve, we should. This bill will help advance those very principles that are a prerequisite for transparency and accountability to the families and communities in which they live. Thank you.
Thank you for your testimony, Mr. McClellan. Next, we have Gregory Sisk from St. Thomas School of Law. If you can please come forward, identify yourself for the record, and give us your testimony.
If I may, real quick, Gregory will be testifying on the QI bill on 1104. Michelle Gross is the next testifier on this bill.
Okay, my notes are mixed up. Michelle Gross, if you can come forward, identify yourself for the record and give us your testimony, we'd appreciate it.
Oh, had a John Thompson moment there. I was muted. My apologies. Chair Mariani and members, thank you for hearing from me this morning or this afternoon. I'm stuck on morning for some reason. My apologies. At any rate, what I wanted to speak about basically is the merits of this bill itself. And I think Mr. McClellan touched on those quite well in terms of giving the families some, respite and some understanding of what happened to their family members. I work with a lot of these families. I've been doing work in this arena for about 35 years, and I work with many families of people who've lost their family members at the hands of law enforcement. And right or wrong, families want to know what has happened to their loved one. They can understand if the shooting was justified or the killing was in some way justified. They're capable of understanding that. But what they are not capable of is not knowing. And this is what is so excruciating to people. I worked on a case, for example, a few years ago in which the BCA had held all of the information under investigation for something like 14, 15 months. And this family was, including holding his body, by the way, for that period of time. And the family was left in the position of not being able to bury their loved one, not be able to understand what happened in the incident. These are just things that I think anybody that sits on this committee who has a loved one, who would lose a loved one and not understand the circumstances, could really relate to. It's really excruciating. I'm working with another family now that is being told that the investigation is not going to be complete, even though it's been under investigation for in the neighborhood of 5 years. And they were recently told that the data won't be made public because the statute of limitations is 30 years. And so this is really wrong to put these families through this kind of excruciating pain. I know that you received a letter from League of Minnesota Cities that talked about the need to balance the rights of the public versus the ability of law enforcement to conduct investigations. But what I want to point out about this bill is we're not asking that this video be made generally public, like that it be broadcast to the public. What we're asking for is for the families to have access to that video footage within a reasonable period of time. I want to read to you very briefly part of a ruling that we got in a case related to data that is supposed to be public at all times in critical incidents. And this was a ruling that was given to us by Judge Bridget Sullivan. And she says, and I quote, "The court notes for the record that these cases, officer-involved shootings, the reasons for the public to have immediate access to specific information, such as the names of officers involved, are compelling. Our common humanity tells us we owe at least this much to the surviving family members." In her affidavit, Michelle Gross explains that one media strategy often used by law enforcement agencies in the immediate aftermath of officer-involved shootings is to vilify the victim. She explains that to be on a level playing field with such agencies, the families of those killed and the public must have immediate access to critical information about the shooting. The court agrees. The court is persuaded that the families of the dead and maimed are entitled to immediately know those responsible. And I think that's a really important recognition of the humanity of these families. I think about the case of George Floyd. While the bystander video was being shown on Facebook and all over the place, and people were looking at it, police information officer John Elder stood outside of City Hall in Minneapolis and said, in the course of an arrest this evening, a man had a medical emergency. Had there not been a bystander video, Mr. Floyd's family would unlikely know, even to this day, what had happened to their family member. And I think that's deeply unfair. It's, we're trying to balance here, and I understand the need for police officers to investigate, but I recognize that families have needs too. And this law is the statute as it exists is too stilted toward law enforcement and does not recognize the humanity of the families involved. And so I ask for us to pass this particular bill in order to rebalance the legislation to take into account the needs of family members. And I thank you for this opportunity to testify.
Very well. Thank you, Ms. Gross. Representative Thompson, do you have any other testifiers? These are the only two that I have listed.
No, we're open for questions, Chair.
All right, why don't we move on to the public testifiers? There are two that I have on the list. Chief Henthorn, I hope I pronounced your last name correctly, sir, from Richfield. If you can come forward, identify yourself for the record and give us your testimony, we'd appreciate it.
Thank you, Chair Mariani and members. My name is Jay Henthorn. I'm the Chief of Police of the City of Richfield, and it's always a pleasure to be here to testify in front of the Public Safety Committee. I'm here today speaking on behalf of the Minnesota Chiefs of Police Association, who represents more than 300 police chiefs across the state and over 150 command staff members. We do appreciate the changes and amendments to this bill, including but not limited to the possible 90-day timeframe to release the video publicly. However, the bill is modeled on Hennepin County's process, and being a chief in that county for the last 7 or 8 years, with full understanding that not all counties have that same process throughout the state. So I would like the committee to take that into consideration for all law enforcement agencies who have different processes. The Minnesota Chiefs of Police Association has significant concerns with House File 1103. Specifically, we believe this bill has the strong potential to undermine the integrity of the criminal investigations that follow an officer-involved shooting or other types of critical incidents. To be clear, the release of body camera or squad car video that shows the use of deadly force to a next of kin is vitally important to ensuring transparency. However, this video is considered evidence and needs to be handled properly as not to compromise the detailed investigation. These investigations are critically important phase for ensuring justice is served in the aftermath of an officer-involved use of deadly force, and we must appropriately balance the need for transparency and accountability with protecting the integrity and the quality of the investigation. Interviews of these directly involved and other key witnesses will usually not have taken place within 48 hours of the incident. These investigations need to be thorough and are extremely complex. And by releasing the video, the balance of protecting the integrity and quality of the investigation could be tainted, as the video could be made public without steps being completed prior to those interviews or statements being taken. Minnesota retention schedules already require us to retain data on body cameras and squad camera video. As CLEOs, Chief Law Enforcement Officers, we are responsible to protect everyone's data. This includes private data as classified in Chapter 13.82, which consists of an active criminal investigative data as it relates to video footage taken by law enforcement, and CLEOs are mandated to protect this data to include redaction of private data as required by that Chapter 13, with video created by the law enforcement agency that is deemed not public. Lastly, I'd like to draw your attention to what the Working Group on Police Deadly Force Encounters recommended the legislature act on. Specifically under Action Step 3.3.2, the report states that the legislature should research and evaluate the impact of body-worn cameras by 2022. If the evidence suggests they contribute to public safety and community trust and provide value in deadly force encounters, the legislature should encourage and fund the full implementation of body-worn cameras statewide. Understanding that communities have local autonomy on the choice to adopt body-worn cameras, we would like the committee to work collaboratively with the Minnesota Chiefs of Police toward this goal that was agreed to by the working group. For these reasons, the Minnesota Chiefs of Police Association strongly opposes House File 1103. Thank you for the opportunity to testify today on behalf of the Minnesota Chiefs of Police Association. Thank you.
Thank you, Chief Henthorn. Next, and sir, you can stick around for questions, I assume.
Correct, Chair Mariani, I can.
All right, very well. Thank you, Chief. Next, we have Tim Leslie, Dakota County Sheriff. Sheriff Leslie, please come forward, state your name for the record, and give us your testimony.
Thank you, Chair Mariani and committee members. I'm Tim Leslie, the sheriff in Dakota County, and I want to thank you for the opportunity to present to the committee again today. We're opposed for a variety of reasons. I'm representing the Minnesota Sheriff's Association, and our opposition aligns with others who are also in opposition. And I just want to bring up the fact that this body and the Senate worked painstakingly to come together on 13.825, which governs the use of police-worn body cameras. And it was extensive, it's hard work, and I think this has been working well. Obviously not perfect, because we wouldn't be here right now if it was perfect, but it does strike a balance with many things that we're trying to consider. The ability to share with others in a manner that's done to protect the privacy concerns of family, witnesses, victims. We note that the bill offers an unedited version. We think of that as somewhat unrealistic and potentially dangerous, as it might expose others and allow for it to be released to the media ahead of a completed investigation. And that could have impacts on both the criminal proceeding and, as you are well aware, the employment proceeding, which is done separate from the criminal proceeding. Some of the events we've been involved in law enforcement over the course of time, we have 10 plus body cameras rolling at the scene, which requires extensive examination so as not to reveal uninvolved persons. And you want to protect those protections on those individuals. The timeline is somewhat arbitrary, the 48 hours all the way to the 90 days. We'd like to express some caution on that. Sometimes maybe the 48 hours could be met. Sometimes the 90 days could be met, but maybe not every time. Because of that, these are fact-specific, very detailed investigations. Staff intensive. We want to properly document and capture what occurred. Superintendent Evans, if he was here testifying today, he'd be expressing that same concern. Once you release that scene, you'll never get it back again. You want to capture what occurred, and you want to get that scene locked down and make sure a piece of evidence is captured. And trying to strike that delicate balance between that and those family considerations is really the goal. Subdivision 2 talks about the altered, erased, or destroyed prior to expiration. Just in case people didn't know, only myself and my designee have access to the body camera footage that occurs in the Dakota County Sheriff's Office. And I would welcome any members of the committee, Mr. Chair, to come down to Dakota County, sit over our shoulder, and I'll show you exactly what we see and how we control those body camera footage that we receive from our deputies that are on the road every day. The no redaction of officer language already exists in 13.825. Again, I appreciate the opportunity to testify today, and thank you for that, Chair Mariani.
Thank you, Sheriff Leslie. I don't have any other testifiers, Representative Thompson, so it seems like this is an appropriate time to open up for questions and comments from the committee. We do have Representative Rowley first. Representative Rowley.
Yeah, thank you, Mr. Chair. I really appreciate it. And I want to echo the chair's opening comments. This is the first time, Representative Thompson, you've been in front of our committee. We've not met yet. My name is Representative Donald Rowley, 38A. I represent Hugo, Minnesota. And the question that I've got relates to the combination of the A1 amendment to the actual language of the bill itself. So if we take a look at the bill on line 1.21, and it starts at 1.20 to 21, it says, with a peace officer's portable recording system be altered. And it says at the beginning, under no circumstances may it be altered. And so the first question that I've got is understanding that when the recording is released, there are redaction requirements, and there is ADA compliant requirements for things like subtitling of the words that are used in the video. Do you believe that, or how would we fix the bill in order to be able to allow things like ADA compliance to be applied to the particular bill, Mr. Chair?
Representative Thompson.
Mr. Chair, thank you, Representative Raleigh. My answer to your question is very simple. The public does not want the remixed version of these videos put out. The public wants clear, unedited video. We can tell when you pause and take something out and replace it with what you want to put in these videos to actually tell a story. You know, a lie, juicy. Truth don't sell. So we want the truth. We don't want an edited version. We can get into the details of Section 2, Section 3, Section 4, or any other sections. But my answer is going to be simple. Again, the public does not want this edited, remixed version to tell a story to protect bad officers. That's what we want. This profession, it's crucial to the integrity of this profession and the livelihood of this profession. We cannot keep protecting bad officers. We cannot. And so that's my answer.
Representative Raleigh.
Yeah, thank you, Mr. Chair. I was talking about ADA compliance. What happens if the person that is receiving the video has no hearing? Again, we've got ADA laws on the books specifically to make sure that everyone has an opportunity to be given the information in a way that they can comprehend.
Representative Raleigh, and obviously the bill is silent on the issue of ADA. I presume we can make all sorts of assumptions that, there's certain, levels of responsibilities for individuals with disabilities to be able to, work with public information, but there are also protocols that exist in state and federal laws relative to information, as well as physical accommodations relative to ADA. I would imagine that nothing, well, let me put it this way. I don't believe that anything in this bill will alter any of the existing protocols and statutes in state law. We can certainly turn to counsel to see if the chair might be barking up the right or wrong tree on that.
Yeah, and Mr. Chair,
the bill is silent on that issue.
Yeah, if I may, Mr. Chair, because my question was two parts and ADA was one of them. The second part is the redaction that's needed. If a child, somebody that's according to Minnesota statute, if a child is 13 or under, is included in the video and is not a material part of the investigation, does this in line 1.21 actually change the law by saying, and I'll read it here, under no circumstances? And what I fear, and again, this then will drive to the A1 amendment, which I'll address after this particular question, Mr. Chair.
Chair, if I would,
Representative Thompson.
I would honestly be happy to work with you, Representative Raleigh, and work with law enforcement on this privacy issue that we're talking about now. I'd be happy to work on that, because that's something that we don't have, is a working relationship. The community always says we don't want to work with the police. There's a certain community, and this is bad. And so I'm offering that olive branch at all times, man. I am not hard to get along with. I'm somebody who's willing to work on it with you, because we have a problem, and that's my answer.
Representative Raleigh.
Yeah, thank you, Mr. Chair. So then I will address the A1 amendment, and in the amendment, I'm going to pull this up. In the amendment, it says that all recordings of incident where a peace officer used deadly force and an individual dies must be released to the individual's next of kin within 90 days. And then it also states that in the actual bill itself, in a different section, I'm not going to call it the exact number, because the point of it is, in part of the bill, it says that the amendment removed the words "or copy," and in the amendment, it says "must release." So how do we release something that hasn't been copied, while also taking into account that the word "altered" says "may not under any circumstances be altered"? And Representative Thompson, I agree, in the spirit of working together and so forth, a lot of the role that I play is in looking at the enforceable language of it and making sure that we don't get into cyclical redundancy of allowing something in one part and not allowing it in another. And I truly believe that your bill creates a cyclically redundant portion with the addition of the A1 amendment from the standpoint of it requires that it's released within 90 days, but then says under no circumstances can it be copied, because it utilizes the word alter. And the definition of an alteration is material change from any state to another state. Mr. Chair.
Mr. Thompson, you can certainly ask your testifiers if they have thoughts on this as well, but Representative Thompson. You might be muted, sir.
I wanted to also give Jonathan McCullum a chance to chime in, but these are great issues that we may need to look at in judiciary and data practices also. So I'll look at the language to see if we need to make any adjustments, but also I wanted to let Jonathan McCullum get a chance. I mean, because we can talk, Representative Raleigh, but there are people here who are really passionate like myself, and I would like to give them a chance to speak on this also.
And it does seem like there might be a more judiciary jurisdiction issue here, but Mr. McClellan.
Representative Raleigh and Chair Mariani. Altered, as I take it, doesn't mean that it's been copied, or doesn't mean that it can't be copied. There obviously with this bill, if a copy needs to be made, it can be copied, but it can't be altered. The copy that goes to after the 90-day expiration can go to the family. It can be a copy, but it can't be an altered copy of that footage, as I understand it.
Okay. Representative Raleigh, and then we do have a number of other of your colleagues with questions.
Yes, Mr. Chair, and this will be the last. I don't know if even this is a question, but I would point the author and the testifiers to the A1 amendment that in line 1.3 specifically called out page 2, line 18, and called to delete and copying. So I believe in my plain text reading of this and the amendment, it looked like copying was addressed and then had to be taken out for the very reasons of this cyclical redundancy. And that's where I guess I'll leave it, Mr. Chair. Thank you very much for my indulgence.
Thank you, Representative Raleigh. Members, make sure you're muted at all times unless you're speaking, because we occasionally get some interruptions.
John Thompson.
Representative Novotny.
I'll let you pay attention. I'll catch you after. Was that for me, Chair Mariani?
Yes, and again, Representative Novotny, I'd ask anyone on this call to please make sure you're muted because we are getting some interruptions here. We want to make sure we hear our members' questions and comments. Representative Novotny.
Yeah, so Chair Mariani, and it's more of a comment because it was covered by both of the testifiers, and Representative Thompson has addressed it as well. But just from a practical standpoint, and being involved in the redaction as a supervisor of video in the past in a deadly use of force, it is a long, drawn-out process. And I still think we want to keep provisions for that minors and unaffected witnesses. I think that's important, and that pixelation and redaction of some of those identities is important. We don't want to lose that. Thank you.
Thank you, Representative Novotny. Michelle Gross did talk about the conversation. It's proper to have, conversation around what the balance is with those, and I take it that's, what we're trying to do in this conversation and subsequent ones as well. Representative Johnson.
Chair Mariani, members, Representative Thompson, I understand what you're trying to do with this bill. I think in the long run, it's actually going to hurt the victims in some of these situations. Looking at it in that 48 hours, a lot of times it takes longer than that just to identify some of the people that could possibly be witness and to be able to talk to them to get an accurate statement from them. So that's a problem. But the current way, if I remember correctly, the way the current statutes reads, in the interest of public safety, that video can already be released. It all depends on the circumstances and generally up to the jurisdiction that has a copy of that. In a law enforcement involved shooting, it's going to be the BCA, and the governor's going to have some say in if it gets released or not. So but if it's released and there's information on there that hasn't been, that could compromise the investigation there, to get a true and accurate investigation, a lot of times they don't want to release that information in that video until they can verify and get in touch with the people, or it might show some things that maybe only the one of the witnesses or even the perpetrator might have known in some of these situations, where they're careful to release investigative data unless it's in the best interest of the public. And that sometimes is a tough decision to make. We also, Representative Novotny brought up the fact of the 48 hours to redact the information. When we discussed this original bill and some of the body cam footage as well, besides the squad car video data in judiciary and civil law data practices, we learned that for about every minute of video that needs to be redacted, it could take up to 1 to 4 hours to redact it. And if you have 8 officers at a scene, all with body cameras, all with squad video, you're looking at hundreds and hundreds of hours of redacting of the video. So I think, personally, I like it best if it's the way this current statute reads, if it's in the interest of public safety. And we've had situations where the jurisdiction with the control of the video would have released it, we probably would not have had some of the incidents that we had. So I think it's important to look at the total circumstances involving of it, giving the local prosecutors a good judgment in what to do. Granted, sometimes I wonder in the judgment of some of the prosecutors with the decisions they make, but they generally, in these situations, it's an elected official, elected prosecutor, usually the county attorney. In some of these instances, it might be the elected official of the attorney general, whether it's released or not. But I think it should be left up to them if it's released or not. If overall it has worked fairly well, especially in greater Minnesota, when they have or have not released the data, the proper information does come out. There has been situations down here where I know if the data, if it had been released to the public, things would not have happened. But there again, that's something you have to take up with your local prosecutors, or because I don't think we've had any issues since the changes yet in that we passed last year. Never mind, that didn't pass. But I think it should be left up to local prosecutors whether it should be released or not, because they have the best understanding of what's going on in their communities. Thank you.
Mariani, may I respond?
Well, Representative Johnson, Ms. Gross, I want to move to a vote in the next few minutes here. I do appreciate your willingness to respond, but we've run over time with 3 other bills before us. Representative Poston.
Thank you, Chair Mariani. My question is a quick one, and it's for one of the chiefs. I am wondering if a chief of police or a county sheriff or any law enforcement, the head of any law enforcement division, has the discretion to watch, not turn over a video to a family, but to watch a video with a family. In other words, can a family member view a video in the presence of the sheriff or the chief of police?
About Chief Henthorn? –
Yes, as the chief of police, and just to go back to what Sheriff Leslie talked about, our processes for review and redaction are the same. I mean, it's either done by myself with their IT staff or one of our other deputy chiefs. In a situation, we could sit down with the family to review the video. Again, I think you would still run into issues of redaction when it comes to the ADA requirements and or juveniles within the video.
Very well, thank you. Representative Poston?
Thank you, Chief. Thank you, Chair Mariani.
Thank you, good question. Representative Lucero?
Thank you, Mr. Chair. And to the bill author, I do share some of these concerns that we're seeing expressed here. Some of them have been involving minors, but you know, I was on the Civil Law Committee when we had discussions in the last several years in regards to the amount of time that body cam footage should be retained and when it should be deleted and things like that. And one of the scenarios that can often be the case is in somebody's house. It's obviously very private, very personal. And we can imagine all kinds of scenarios where a law enforcement incident requires a law enforcement officer with a camera that's recording to enter into somebody's private home. And let's say everybody's an adult. Let's say it's multiple roommates. Let's say it's adult children, whatever the scenario might be. And let's say there's adult people that happen to be naked in the video. They might have gotten out of the shower, right? There was a call from another adult party in the house, and another adult was unaware of what was happening. They get out, and this is all caught on the video camera. That's private and personal. And they may have nothing to do whatsoever with any situation that might end up with the use of deadly force. Not even death, right? Because it's deadly force. I think is also, let's see, is it just deadly force? Actually, I will ask that question, Mr. Chair. Is it involving just deadly force or death?
Representative Thompson?
The bill's read, it's deadly use of deadly force.
Representative Lucero?
Okay, so it's only deadly force. Okay, so imagine the scenario, though, where you have somebody who's in a compromised position who has nothing to do with the incident whatsoever. That unedited then is going to go. Mr. Chair, does the bill author see a concern with all kinds of scenarios where, since an unedited version has to be made available to other parties, that it might compromise the safety, security, the embarrassment of parties that may be on footage, but again, not involved with the scenario at all. They just happen to be in the wrong place at the wrong time.
Representative Thompson, quickly to the question of your concern.
It was funny that he asked about, my mom used to always say, if was a fifth, we'd always be drunk. So we got a lot of what ifs here. That's one thing. But here's something that is unique about what he's asking about a naked body. It was just a young man hiding in the dumpster in St. Paul, completely naked. And they asked him to get out of the dumpster. When he got out, not only did they shoot him, they sick dog on him. And so that just came to my mind when he's talking about what if somebody was naked in a video, would I want it to be released? What I want to be released is the unedited video of wrongdoings of police officers. I don't want this what we have now to allow bad officers to flourish. This is simple acts. And so I hear a lot of what ifs and this and that, but I'm right to the point. This is exactly what we're asking for in these officer-involved shootings. And if you will, Chair, give me one more second just to let Michelle just give her 2 seconds to elaborate on the what if.
Representative Thompson?
You hear me?
Yes. Did you want to add something or?
You heard nothing I said?
Oh, no, I heard you ask for 2 seconds to.
I was asking, would you allow Michelle Gross 2 seconds?
Ms. Gross.
Yes, thank you. Basically, what I wanted to add is just that under 13.82 subdivision 2, right now there's a wide array of information that is available in police critical incidents and to the public. And the wording is available to the public at all times from the originating agency. So not the BCA, not the prosecutor, but the originating agency. And that, again, it's a long list of data, and it even includes, certain videos, in other words, squad cam videos. But what isn't permitted because of the carve out that's in 13.825 is body camera footage. So body camera footage is being treated in a very different way. Secondly, I do want to point out that we're not asking that things be released to the general public. We're merely asking for things to be available to the families. And that's a very different ask. And so I want that to be clear to people. And again, recognize that much of this other data is available and pretty much immediately under 13.82 subdivision 2. And that's all I want to point out. Thank you.
Very well. Thank you, Ms. Gross. Representative Frazier.
Thank you, Mr. Chair.
Mr. Chair, I still had one more question.
Representative Lucero, we're going to go to a vote in a few minutes, and so I'm going to ask Representative Frazier to ask the last question, and then we're going to go to a vote. Representative.
Thank you. I appreciate the indulgence, Mr. Chair. Okay, well, I'm not satisfied with that, Ann. I'm sorry. Is that for me, or are you recognizing Frazier?
I am.
Oh, okay.
Thank you. Representative Frazier.
Thank you, Mr. Chair. I just wanted to quickly, it's more of a comment. I think, municipalities right now are not required to have body cameras. I know in the city that I live in, we're going to get body cameras in the next few months as we're moving forward. But I will point out that the body cameras are there to provide information, to make sure, so the officers have that information. If something goes down, we have evidence of what happened, right? It can protect the city. But in the same instance, we should be able to provide that information to families that are being impacted by this if there was an error, so they can see that. I think that does kind of create some more of this transparency and trust building that we're trying to do as we look at the kind of police reforms that we want to put in place. I think what Rep. Thompson is trying to do is strike the balance there. I've heard him say he's willing to have more conversation around tweaking his language if possible. But I think at the end of the day, he is bringing language forward with these community activists to strike the balance, just to provide that information. The one issue that I think we all should recall and think about is the Laquan McDonald situation that happened in my home city in Chicago. They held that information for over a year. And then when we saw it, we saw why they held that information. We don't want situations like that here in the state.
Well, Representative Thompson, last 5 seconds, and then we're going to move to a vote.
Thank you, Chair, and thank you, everyone, for all this. This is a conversation that's long overdue, Chair, and I don't apologize for having it in your committee. I don't apologize. This is the perfect place to have it. These are hard conversations to have, but keep in mind that the public is who we all serve, and their best interest is always should be our best interest. And so I'm 100% willing to work with everyone on the language, everyone here, and to try to get this right, and some of the tweaks. But I just want to make sure that we get it right. We don't want to have, laws on the books that protect officers and allow them to flourish when they know they should be out. Because these are the officers that make this profession look bad. And I know we don't like our coworkers making us look bad. And so I just want to make sure that I reiterate, I want to be able to sit down and have these conversations and work on this together. And I thank you, Chair, for having me.
Thank you, Representative Thompson. The Chair renews his motion that House File 1103 as amended be referred to the Committee on Judiciary. The clerk will take the roll.
Chair Mariani.
Aye.
Chair Mariani, aye. Vice Chair Frazier.
Aye.
Vice Chair Frazier, aye. Representative Johnson.
No.
Representative Johnson, nay. Representative Edelson.
Aye.
Representative Edelson, aye. Representative Feist.
Aye.
Representative Feist, aye. Representative Grossell.
No.
Representative Grossell, nay. Representative Hollins.
Aye.
Representative Hollins, aye. Representative Hewitt.
Aye.
Representative Hewitt, aye. Representative Cleavorn.
Cleavorn, aye.
Representative Cleavorn, aye. Representative Long.
Aye.
Representative Long, aye. Representative Lucero.
No.
Representative Lucero, nay. Representative Mueller.
Mueller votes no.
Representative Mueller, nay. Representative Novotny.
No.
Representative Novotny, nay. Representative O'Neill.
O'Neill, no.
Representative O'Neill, nay. Representative Pinto.
Aye.
Representative Pinto, aye. Representative Poston.
Nay.
Representative Poston, nay. Representative Raleigh.
Raleigh, nay.
Representative Raleigh, nay. Representative Vang.
Aye.
Representative Vang, aye. Representative Zhang, excuse.
Aye.
Representative Zhang, aye. That concludes roll call with 11 ayes and 8 nays.
Very well. On a vote of 11 ayes and 8 nays, the motion prevails, and House File 1103 as amended is referred to the Committee on Judiciary.